I'm J. Jermaine Bay, Melodium Morris Pradium, Ante, Colorado. The acronym is AMPAC. I am the Chief Judge of Consular Court. Today is Class 113. Class 113. What do we learn in Class 112? Well, we're starting to wrap up, right, one of the resolutions that we was going over, and that resolution is about how can Moroccan Moors, right? When I say Moroccan Moors, well, what does that mean? Well, the Moor is just simply Moroccan, period. But why do I turn around and say Moroccan Moor, right? Well, both of those are the same words, right? You got Moroccan and you got Moor, but Moors are familiar with the word Moor, right? But you must always understand, Moors, you got the Moroccans in the Kingdom of Morocco, right? They'll say, oh, we're the Moroccans, right? But they also call themselves Arabs. They'll say that they're Arab Moroccans. If you read their constitution of the Kingdom of Morocco, it clearly states they're about the Arab, paired Arabs, right? Paired Arabs, right? It's about to come together of Arabs. So they say they're Arab Moroccans, right? So when you hear me say Moroccan Moor, well, yeah, it just simply should say Moroccan. But what I'm trying to get the Moors to understand, there is a distinction between the Moors over here who are Moroccans versus the Moroccans that are on commonly known as Africa's west coast, right? Northwest. So I'm trying to make the distinction, right? Because you got all kind of Moors everywhere on planet Earth. You got Spaniard Moors, you got French Moors, you got British Moors, you got Poland Moors, you got Russian Moors, you got Chinese Moors, you got Colombian Moors, you got Venezuelan Moors, you got all types of Moors on planet Earth, right? But the reality is we're just simply Moroccans. So when you hear me say Moroccan Moors, it's just me making a distinction between the Moors in the West, right, versus Moroccans over in Africa. And at some point, we'll even get past that terminology. We'll just simply say we're Moroccan nationals. And that's the end of the conversation. But right now, we're at varying stages of advancement. Right? So therefore, when you hear me say Moroccan Moor, just understand, I know those are two words that mean the same. But I'm trying to get the attention of Moors, because Moors all this time kept saying, we're not Moroccans, we're Moorish Americans. Well, that's not true. You're not Moorish American. And the vast majority of so-called Moorish Americans don't even realize the word Moorish means Moor rocking. So I have to say Moroccan Moor just to get the Moors' attention. They're still learning they're actually Moroccans, even though they've been Moroccans the whole time. Our consanguinity, our bloodline is Moroccan, period. However, how do we become Moroccan nationals? Well, now we have to follow the prescriptions, right? The provisions of our own Moroccan treaties. And there lies the distinction, right? You got Moroccan Moors, you got Moorish Americans, right? You got all these distinctions of Moors, and it's ridiculous. So at the end of the day, at some point, we will just simply say we're Moroccan nationals, period. But we're going through varying stages of education. And that's what this is all about educating people and taking them through phases to get to a point where they can absolutely say to the people, I'm Moroccan. And they don't have to explain nothing else, right? So we'll get there, right? Okay, what else did we learn in Class 112? Well, we were trying to finish up, like I said, let's go to the board real quick, right? Keeping in mind that we're still going over the Charter of the United Nations. So what do I have on the board? I got the chapter, right? The Charter of the United Nations, Chapter 7, Articles 39 through 51. And what is Chapter 7 about? It's about the action with respect to threats to the peace, breaches of the peace, and acts of aggression. So what the Moors are learning about right now is when we start to deal with threats, right? Breaches and aggression, how do we protect ourselves? That's the question. All the Moors have been trying to learn for decades, how do we protect ourselves as a people, right? Well, international law has started to put in certain terminology that talks about protection, right? So what's that terminology? What the Moors have been dealing with all this time, we've been dealing with actions, right, of threats, breaches, and aggression against Moors. The United Nations have set forth to say, okay, you Moors need to understand that everybody on planet Earth understands how you deal with threats, breaches, and aggression. And everybody on planet Earth knows it starts with first protecting your people based on their self-determination and coming back into statehood. And the state starts to protect the people. Well, how is it the state protects the people? Well, the state has three branches of government. And through the three branches of government, you start to act what's called legislation or laws or statutes, right? Understanding that legislation, law, and statute is the same word. It's semantics, okay? It just simply means law. Right? So you needed laws to protect your best interest. And the Moors not only were stateless, well, actually, they were lawless as well. What do I mean? Okay, well, let's read right here. It'll tell you. Okay, so in class 112, we were reading over a convention, right? Keeping in mind, conventions are treaties, right? Don't get caught up in the word convention. It's simply just a treaty. But what did the title tell you? It was about the United Nations Convention on the Prevention and Punishment on the Crime Against Internationally Protected Persons, right? That was a convention or a treaty of the year 1973 we're reading over in class 112. But what's the key word here? Okay, Moors have to understand what? How do you protect? How do you protect? How do you protect persons? Okay, how do you protect the persons? Okay. Well, the answer is laws. Your laws protect your people. And unfortunately, Moors were not only in the absence of laws, but they actually were stateless. So if you're stateless, you couldn't enact laws. So when the Moorish Americans, right, as an example, say, well, they're breaching my rights. These are my inalienable and unalienable rights. Well, that sounds good from a verbal decree. But how do you put that into practical account? How do you prove that? Well, you have to prove it through your laws. If the colonists are breaking your laws, now you have what's called a legal argument, right? You have a legal defense. If you say someone's doing something to infringe against you, then you must prove it. How do you prove it? Well, you say, well, first of all, they're breaking the law, right? So if I ask Moorish Americans, okay, if you're trying to prevent something, you want to protect yourself, which means you're trying to prevent something. How do you prevent? For the United States of America, the United States, and there's several chartered union states from doing something to infringe against what you consider your rights, right? Rights are always in writing. It's called laws. And the Moorish Americans were in the absence of laws. Moorish Americans don't write laws. Moorish Americans don't have statutes. Moorish Americans never had legislative acts because Moorish Americans didn't have three branches of government. You didn't have a legislative branch. Only the legislative branch can come up with laws. There's no such thing as a Moorish American legislative branch of elected officials. There's no such thing as a Moorish American executive branch, where it's a head of state and all the cabinet officials that come along with that. There's no Moorish American judicial branch of elected judges. There's no Moorish American state. There's no Moorish American constitution. And I'm not talking about your constitutions that are private law of your churches. I'm talking about a ratified, deposited, and promulgated constitution in accordance to international law. So what you must understand, Moors, is that all this time as Moors, not only were we stateless, we were lawless because we were in the absence of laws that would have protected us. And there's not one Moorish American out there that can ever produce anything, not one law that says, here's the law they breached. They can't produce even a loose leaf piece of paper that said this was a law that was a bill at first, that was in the legislative branch of the Moorish American state, and the legislators of the Moorish American state, through the legislative branch, passed that bill, right? They ratified it, they signed it, accepted it, and then passed it over to the executive branch of the Moorish American government. And then the Moorish American head of state of the executive branch signed that bill into law, making it legislation, making it a statute, right? That's never happened. So the Moorish Americans kept saying, well, they're infringing against my rights. Well, what rights? Prove it. What's your legal argument? Where's your legal defense? You have to prove it. It's got to be set forth. The United States has all kinds of statutes. You know why the United States has statutes? It's because the United States has a, what? Legislative branch. Got the House of Representatives and the Senate. They're passing bills. They pass it over to where? The executive branch. And the executive branch, commonly known as the President of the United States, signs it into law, and it becomes law. It becomes statute. It's legislation. Then it enforces it upon anyone who's an American citizen. Guess who else does that? just several chartered states. Let's use state of Alabama as an example. State of Alabama has a governor, right, which is executive branch. State of Alabama has a legislative branch, right? And they have a judicial branch. And they're constantly passing bills into what? Law. That they refer to as being statutes. And then they enforce it through their law enforcement officers as well as their what? Judicial branches, the third branch, to rein in the order. Anytime somebody breaks what? The law. So the Moorish Americans this whole time kept saying, they're breaking the law. Okay, what law? Produce it. Where's your legislative act, Moorish Americans? Where's your laws, Moorish Americans? Where's your statutes, Moorish Americans? It don't exist. You know why it don't exist? Because you're stateless. You know another reason why it don't exist? Because there's no such thing as Moorish American. It's a more or less a made-up terminology under what? A church status. It's no different than saying you're Baptist. The United States only recognizes the term Moorish American under a religious organization. They keep saying it out loud. Religious organization, religious organization, religious organization. And even when you don't mention the organization part of it, you turn around and say incorporated. So which one is it? Is it a 501c3 corporation? Or is it just a civic corporation or organization? But no matter which one you pick, guess what? Neither one of them is what? A state. Now, I don't say this to be adversarial with the Moorish American because I love all the Moorish Americans. Those are our brothers and sisters. But what I'm trying to do is bring clarity to you to show you where we've made our mistakes. I'm showing you that you are not clairvoyant in understanding law. And ignorance of the law is no excuse. We've been lawless people. We didn't have our own laws. So since we didn't have our own laws, guess what we ended up doing? Trying to enforce the Constitution of the United States because we were in the absence of our own Moroccan Constitution. Since we didn't have our own Moroccan Constitution and statutes, guess what we did in the place of that? We started trying to enforce the United States statutes. We started trying to enforce the municipal laws of the several union states. And by definition, the Moors didn't even realize that means you were utilizing the protections of their laws, which made you a protected person. That made you a ward of the state. Because you're using their statutes, their municipal laws for your own protection. And this is what Moors have to understand. You were not using Moroccan laws for your defense. Think about the oxymoron about what I'm about to say. You said they breached your rights. Then you turn around and say your rights are found where? In their statutes. But you say you're a Moor. You say you're a foreign national. And you turn around and use their foreign laws for your defense. Instead of you using your own laws of your own state. Because the United States would be breaking the law if they were breaking the laws of your state. And what you have to understand, like I said, it's not me having an adversarial position against Moorish Americans. I'm trying to teach and show clarity. I used to be a Moorish American. I started to get clarity once I started studying international law. That's the key. I had to stop studying the municipal laws of the several union states. I had to stop studying the statutes of the United States. Who cares about their res judicata? It ain't Moroccan law. Who cares about their stare decisis? It ain't Moroccan law. Who cares about their precedent? It ain't Moroccan law. Who cares about their case laws? It's not Moroccan case laws. The treaty said you have to return to Morocco through a Moroccan government. That's what the Treaty of Madrid of 1880, Article 15, paragraph 1 says, return to a Moroccan government. Well, there's no government without a state. That means you got to come back to what? Moroccan state government that has its own what? Laws. It has its own statutes. It has its own legislation. And once you do that, now, listen, Moors, now you're protected. Now you're a protected person. But wait, what type of person? All Moroccan nationals are human beings within their state. You're the natural person. But the state is an artificial person that protects you and you protect it. Without the state, you can't enact laws. The whole world only recognizes states. They only represent states. Only states can enact laws. And unfortunately, the Moorish Americans have been stateless, which means they don't have no laws in the absence of laws. Which means we could not protect ourselves. We couldn't protect any person. We couldn't protect the natural person, and we couldn't protect the person commonly known as the Empire of Morocco. Because the Empire of Morocco is a person as well. It has a name. You know what the name of the Empire of Morocco is? Empire of Morocco. That's his name. It's a person. Has anybody met the Empire of Morocco in person? No. We love to say Morocco, Morocco, Empire. Okay, you ever met somebody named Empire? No. You ever met somebody named Morocco? No. So therefore it's an artificial person that we all pay allegiance to, that we all recognize as being a being one way or another. We say, oh man, it's the soil, man. It's the organic soil. It's the allodial soil. The soil can't name itself. It can't speak. Guess who speaks for the soil? The human beings. So the Empire of Morocco in itself is a name. And we have to operate it through a piece of paper commonly known as a constitution. And the constitution then recognizes the land as being the name that you named it. But how all states on planet Earth interface is through these constitutions. And the constitutions are commonly known as state constitutions. And it's the only way we're going to get protections as the human persons or as the artificial person of our state. We have to protect the artificial person. Artificial person has to protect us as human beings. We got to protect each other. So you want a policy of protections? Then you need the umbrella of a state. And until then, there will be no protections for Moors. That must be understood. All right? Let's get into the class. As you know, I always open up the Constitution. Without the Constitution, you cannot protect, right? You cannot protect your internationally protected persons. Who protects the internationally protected persons? It's the state. And it's officials. But there's no officials without the state. The state recognizes the officials. Do you see this terminology right here? Internationally, right? Internationally. That means all the Moors who sit in an official position of their state, their elected official or appointed official, they're operating on an international level. They have international immunity, no matter where they go on planet Earth. Which means if you have international immunity, right, privileges and immunities, that means even Americans can't touch you. You're in a bubble. What extended you those protections? The state. So everything more should be doing should be on an international level. Noble Drew Ali was operating on an international level. Good brother Malik Shabazz, commonly known as Malcolm X, was operating on an international level. Marcus Garvey was operating on an international level. They were into politics, geopolitics at that. Are the Moorish Americans operating on an international level? The answer is no. Because Moorish Americans are not even a recognized political people. Moorish Americans are recognized as a church organization. And that's the truth. You know how I know? Because they keep talking about the temple. Everything must go through the temple. That means you're recognized by a temple and not recognized by a state. Now, I don't say that to be condescending. I'm just telling you the truth. This is what Moors are saying. So that means you have no protections. Because your church don't operate on no international level. It's domestic. Make it so bad, all the churches, mosques, synagogues, right, temples, are all registered to a jurisdiction. What jurisdiction is your temple registered to? And you know what the jurisdiction is? The American jurisdiction. Because you still a protected, naturalized Moorish subject in their jurisdiction. So therefore they have civil and criminal jurisdiction over your temple and all the Moors that are participants of said temple. That must be understood. The Moorish Americans have no protections. Now I'm going deep into this because we're talking about protection. Today we'll start reading over a little bit of the United Nations Convention against the taking of hostages. Because Moors keep saying, we're kidnapped, we're hostages. No, you're not. You keep saying that because you think you're a foreign national. My question to you is, prove it. What state recognizes you as being one of their nationals? That's my question. Let's just start right there. And you can't even prove that right out the box. You're not foreign. You're a citizen because you've been naturalized under the 14th Amendment. You're an American citizen, but you're a naturalized American. That means you're not truly American. That means you're what? Moroccan, but you've been adopted under their protections. And that's why your last name, your surname, your adopted family name is American. That's why you keep saying Moorish American, because you keep recognizing your adopted family members who adopted you, and you don't want to let it go. Your adopted parents called you black. You don't want to let it go. Your adopted parents called you Indian, and you don't want to let it go. You know the name your adopted parents did not name you? Moroccan. They've tried to erase that history out of you under naturalization. But for some reason, you keep wanting to be American. And I wonder why. Well, I can tell you why, because your Moorish American teachers keep telling you that you're the true American. They're lying to you. The treaties say otherwise. And the whole world knows that you're Moroccans. The whole world knows this, except for you. Let's get into the class. AMPAC study sessions contact information. As you can see, as the Moors know, we're still going over the Charter of the United Nations of 1945. We've already read over Chapter 7, right? And it's Articles 39 through 51. And now we're starting to take a deeper dive in what's commonly known as counterterrorism, right? And the United Nations have set forth certain conventions and declarations, right? Resolutions, and all of these are treaties. Anytime the United Nations writes anything, it is a treaty because it immediately, if two or more states sign it, it's a bilateral treaty. If two states sign it, it becomes a multilateral treaty when three or more states sign it. It's a treaty. And the United States, in their own Constitution of 1789, and their Constitution of 1871, Article 6 says that what? Treaty supreme law of the land. And all treaties made, or which shall be made, shall be the supreme law of the land. But what's the name of the land? Morocco. But what's the name of their jurisdiction? America. So the land is Morocco, but their jurisdiction is America. Okay, well, what about Moroccan jurisdiction? Where is it? There lies the problem. It's been dormant. It's always existed. But we as Moors have to bring it back to life through the proper written instrument commonly known as constitutions in each of the territories. All 50 territories of what's commonly known as the United States jurisdiction have to be restored back into a Moroccan jurisdiction. That way Moroccan law reigns supreme. It is the supreme law of the land. What is supreme law of the land? Treaties. Which treaties? All of them. Anytime the United States put their name on a treaty, that becomes supreme in their American jurisdiction. Every time the Moors put our name on a treaty, that becomes the supreme law of the land. And just so happened, the Americans and Moroccans have been putting their names on the same treaties. But Moroccan law always reigned supreme because the United States themselves said treaties supreme law of the land, and the treaties are based in what? Moroccan law. They just don't want to tell you this. But you don't have to worry about them telling you. You need to be telling them because you're supposed to be sitting in three branches of government, overseeing the great enterprise, commonly known as the Empire of Morocco and all the assets within it, commonly known as the charters of the United States, as well as the United States itself, international organization. So what we're learning now is through the United Nations, they have set forth an office called the Counterterrorism Office. Well, what does that mean? Well, they start to set forth certain treaties that talked about acts of terrorism. Right? This is what we're learning. These are reference points. So they set forth what? International legal instruments. Do the Moorish Americans have international legal instruments? No. They're too busy trying to enforce the United States statutes, and the several Union states res judicata, the several Union states case law. They're not focusing, the Moorish Americans are not focused what? Internationally. That's the problem. They don't study international law. And look, and it's so easy. Look, and it's free. You ain't got to pay for no package. You go straight to the website and all the information's there for free. Nobody's selling you no PDF. It's free information. Moors turn around and say, yeah, man, give me 50 notes for access or a copy of this. Yeah, give me 100 notes. They're always begging for something. And everything's free. Everything I learned for free. Mm-hmm. Everything I share it to the Moors for free because I studied it for free and I teach it for free. Because it's going to help us get our what? Freedom. What does freedom mean? Free from what? The dominion of the United States civil and criminal jurisdiction. Stop charging Moors for every little daggone thing. Get over yourself already. Go get a job and help the Moors. Work a 9 to 5. Put your 32 to 40 hours in a week at a job, and when you come home, help the Moors. But stop living your lifestyle off the Moors. This is shameful. Stop charging the Moors to get access to what you consider a remedy. If it's a remedy, give it away. Stop selling books. If you think your book has a remedy in it, turn it into a PDF and put it online for the Moors, because the Moors is your family. Who the heck charges their mother, father, brother, sister, uncle, and auntie for something that's going to be a remedy to your family? You don't charge your family. This is sad. I recently just saw a Moor just post some stuff for 50 bucks online because he think he got a win. He got a bronze medal. Now he's selling something for 50 bucks online because he think he got a win. It's not a win. Even if it was a win, why sell it? Give it to the Moors. We're family. I don't get it. Why? Who taught us this? You know what the problem is? Good brother Nas said it best. The problem is we started thinking like the colonists until Noble Drew Ali started dropping it. And you know what the colonists think about first? Capitalism. Everything's about making a dollar. And we think just like them. And you know why we thought like that? Because we were individual Moors. But see, when you come back into statehood and you become an officer of your state, you can't sell nothing else. So that's going to put an end to all this packet selling, just the fact that Moors are establishing governments. And when you're a government official, you can't be charging people because you have an obligation to help them in the first place. Let's continue. Okay, as the Moors know, matter of fact, let me go back up. Let's read over this paragraph as a recap, right? Let's understand what the United Nations put together regarding an international legal instrument. Let's just read this paragraph, okay?
International legal instruments. Since 1963, the international community has elaborated 19 international legal instruments to prevent terrorist attacks. Those instruments were developed under the auspices of the United Nations and the International Atomic Energy Agency, the IAEA, and are open to participation by all member states. Here is a summary of the 19 universal legal instruments and additional amendments dealing with terrorism. For the full text of the documents, click on the title.
All right, so we're scrolling down because we're learning about what? What are we learning about right now? Well, we're learning about how to prevent. How do we prevent terrorist acts? Mm-hmm. Right? Because the United Nations have listed as what? You're dealing with what? Terrorism. These are their words. Okay, Morris, how do we prevent terrorist acts? That's the question. Okay, they give you the answer. They say, oh, if you want to prevent terrorist acts, because we say the colonists are terrorists, but they're alleged terrorists. It says, how do you prevent it? Well, you have to enact what? You got to enact some legislative acts, such as this one. Instrument regarding the taking of hostages. Mm-hmm. This is how you prevent these acts. It's because they know they're breaking what? The law. So now your legal argument is what? Now you produce an instrument that was passed in your legislative branch over to the executive branch and signed into the law that says something like instrument regarding the taking of hostages. What type of hostages? Moroccan hostages. Now you're standing on the well-settled principle of your Moroccan law. But international law has already set forth the language. Because your officers of your state are automatically protected according to international law. Automatically. But then you have to bring this same document, this same treaty, back to your state and become a party to it so you can enforce it. It's like any contract. If your name ain't on the contract, you can't enforce it. Moorish Americans don't have their names on no contracts. Zero. Name me one Moorish American that has ratified, deposited, and promulgated and become parties to the Treaty of Peace and Friendship. Give me the name. You know my email address. You know my phone number. Give me the name of a Moorish American group, person, organization that's parties to the Treaty of Peace and Friendship. Prove it. You can't prove it. So how do you prevent terrorist acts? You need legislation. You need laws. You need statutes. That's what this is. It's too easy. So the United Nations is schooling the Moors. They're schooling the Moors, say, you Moors need legislative acts. Right? Because you Moors been dealing with what? What have the Moors been dealing with? Okay, let's read this. Let's read this title in here.
Instruments regarding the taking of hostages. 1979 International Convention Against the Taking of Hostages provides that, in quote, any person who seizes or detains and threatens to kill, to injure, or to continue to detain another person in order to compel a third party, namely a state, an international intergovernmental organization, a natural or juridical person, or a group of persons to do or abstain from doing any act as an explicit or implicit condition for the release of the hostage commits the offense of taking of hostage within the meaning of this convention, end of quote.
All right, so if you're a hostage, that means you must be a national of the state that's being held hostage in the jurisdiction of a foreign state. or some foreigner has come into your state and holding your national hostage within your own respective state. But what was the key word to everything I just said there? What was the common denominator? The word state. Mm-hmm. What makes you a foreign national is when you go across the border into someone else's state. That makes you a foreigner. However, if you're just simply the national of your state and a foreigner comes into your state, that's the foreigner. You're just a national of your state. That foreigners come in to perform a terrorist act. Okay, let's apply that to Moors. If the American, right, federal government, or if the American charter states and their officials do anything that appears to be a terrorist act, well, automatically, according to the treaties, they're already listed as what? Foreigners. Their foreign charters, i.e. their states, are all foreign in Morocco. They know this already. They're already listed as foreigners. So anything they do is a foreign act, and this is why it's listed as terrorist act. They've been terrorists. They're trying to terrorize Moroccans in their own homeland. Well, we just can't say that. We got to prove it. Where's our laws that we can stand on and say, see, right here, you're breaking the law? That's our legal argument. That's our legal defense. We can prove what they're doing. They're breaching our laws. Okay? All right, so we're going to click on it. Okay, now we left off on Article 1, but let's take it from the top. Okay, let's just do a quick recap. All right.
Multilateral International Convention Against the Taking of Hostages, adopted by the General Assembly of the United Nations on the 17th of December of 1979. The states parties to this convention, having in mind the purpose and principles of the Charter of the United Nations concerning the maintenance of international peace and security, and the promotion of friendly relations and cooperation among states, recognizing in particular that everyone has the right to life, liberty, and security of person, as set out in the Universal Declaration of Human Rights and the International Covenant on Civil and Political Rights.
Pause. Okay. Paragraph 1 and 2. Let's knock this out real quick. Recap. First of all, it starts out saying what? The states party to the convention. So who can be a party to the contract? Only states.
Yep.
Okay, paragraph 1. Having in mind the purposes and principles of the Charter of the United Nations concerning the maintenance of international peace and security and the promotion of friendly relations and cooperation among states. Recognizing in particular that everyone has the right to life, liberty, and security of person as set out in the Universal Declaration on Human Rights and the International Covenant on Civil and Political Rights. So both of these are declarations, right? Both of these are treaties. Mm-hmm. What's the treaty? Universal Declaration on Human Rights. That's a treaty. Are the Moorish Americans a party to it?
No.
No. Because why? They're lacking 3 branches of government. They never passed a bill that would recognize the Universal Declaration on Human Rights and never became a party to that contract, to that treaty. What else? And the International Covenant on Civil and Political Rights. Have the Moorish Americans become parties to that treaty? No. But let's take a quick snapshot of it, okay? Let me get a Moorish example of what I'm talking about. All right, hold on. Okay, here we go. All right. So this is United Nations, right? United Nations resolution, right? But keep in mind, everything they write is what? A treaty among states, okay? Just a quick snapshot. This of 1966 is ratified 1967, but listen, okay. We're going to read the preamble and Article 1. That's it. As a brief. Moors go back and read this themselves, but I want the Moors to see what's up. Why is the United Nations invoking this? They're trying to tell the Moors, hey man, you can find some rights in those treaties, become a party to it, you can enforce it against the United States. That gives you a legal argument, a legal defense, because now you have what? Laws. Now you have what? Statutes. Now you have what? Legislation. Which means now you can say they're breaking your what? Laws. Well, here's a law that the Moors should become a party to, so we can enforce against anyone that's breaking our laws. Okay. All right. So let's read this from the top.
International Covenant on Civil and Political Rights. The states parties to the present covenant, considering that, in accordance with the principles proclaimed in the Charter of the United Nations, recognition of the inherent dignity and of the equal and inalienable rights of all members of the human family is the foundation of freedom, justice, and peace in the world. Recognizing that these rights derive from the inherent dignity of the human person. Recognizing that, in accordance with the Universal Declaration of Human Rights, the ideal of free human beings enjoying civil and political freedom and freedom from fear and want can only be achieved if conditions are created whereby everyone may enjoy his civil and political rights, as well as his economic, social, and cultural rights.
Pause. What are political rights? You say you can enjoy your political means what? State.
Yeah.
State means what? Political. These words mean the same. That means the Moors could not enjoy their political rights because the Moors were stateless. We had no political rights. We certainly have no geopolitical rights. What does geo mean? Geographic, right? What claims the geographic land? It's a constitution. That's the contract that claims what? The latitude, longitude, that geographical location based upon the borders of your state. That creates political rights. The state constitution identifies the landmass. Okay, next.
Considering the obligation of states under the Charter of the United Nations to promote universal respect for and observance of human rights and freedoms.
Paul, so who's reserving your rights? States. Okay, Moorish Americans, tell me the name of the state that's reserving your rights. It don't exist. I'm trying to help the Moorish Americans here because that's family, right? Sometimes you got to just have straight talk with your family, right? But we all know that the truth can be messy. But the thing is, what are we going to do? We got to bring some clear water, right? It's one thing to point out problems, but what's the solution? That's the difference about an AMPAC study session. AMPAC study session, the educational platform is going to point out the dirty water and then offer you what? Clean water in exchange. But then you go look at the reference point yourself. You read it. It's on you. Don't be in fellowship. Be in scholarship, right? So be in fellowship of the scholarship of you reading it yourself. That's what this is all about. Okay, next.
Considering the obligation of states under the Charter of the United Nations to promote universal respect for and observance of human rights and freedoms, realizing that the individual having duties to other individuals and to the community to which he belongs is under a responsibility to strive for the promotion and observance of the rights recognized in the present covenant. Agree upon the following articles.
All right, so we're just going to read Article 1.
Article 1. 1. All peoples have the right to self-determination. By virtue of that, they freely determine their political status and freely pursue their economic, social, and cultural development.
Paul, so right off the top, Article 1, Section 1. All peoples have the right of self-determination. How do you determine yourself? Who determines who you are? The state. The state has your name on the registration of the state. The state recognizes you and you recognize the state. It's a duality of recognition. So based upon self-determination, the self-determination means what? To get back into political rights. And political means state. You need state rights, and the state reserves the rights to protect you. And your rights are then protected under the state. Then you turn around and protect the state itself. So self-determination is you talking about, I'm an individual more. No. The self-determination is the state. Then the state recognizes you. That must be understood. Self-determination ain't about you standing on your individual square. The square is the state. It's the borders of the state. That's the square. Okay, section 2.
2, all peoples may, from their own ends, freely dispose of their natural wealth and resources without prejudice and to any obligations arising out of international economic cooperation based upon the principle of mutual benefit and international law. In no case may a people be deprived of its own means of subsistence.
All right, so right here it says how you derive your rights. International law already recognizes your rights. But what does international law says that the criteria is? What's the main scope that you have to adhere to? Okay, it says you have to be assessed to what? A state, right? This is about state rights, right? It's all about states, more. Going back up. Whose parties? No.
The states parties to the present covenant.
So it's about the state.
Yeah.
International law is grounded in state. That's it. I'm being redundant here for a reason. Okay. Article 1, Section 3.
3. The states parties to the present covenant, including those having responsibility for the administration of non-self-governing and trust territories, shall promote the realization of the rights of self-determination and shall respect that right in conformity with the provisions of the Charter of the United Nations.
Okay, so Article 1, Section 3. Listen up, more. The states parties to the present covenant, including those having responsibility for the administration of non-self-governing and trust territories, shall promote the realization of the right of self-determination and shall respect that right in conformity with the provisions of the Charter of the United Nations. What is that saying? It says the Moors, as the natural inhabitants of the land, as the indigenous people of the land, that these colonists, right, are practicing colonialism in Morocco, right? But international covenants recognize them as being what? The United States is considered to be an administrator. They're administrators over our land. They're administrating what? Protections. This whole time, the United States has been protecting us because they put us under the umbrella of their what? Laws. Now their laws protect us. So when Moors turn around and break their laws, that makes you what? An outlaw. Because we've been under their protections because they adopted us as Americans. We were Moroccans, and they gave us the last name of American. That's the family name for them. Now you run around saying you're Moorish American, and you don't know that you're paying honors to your adopted family members. So under this section 3, what is a non-self-governing territory? Well, that's all the 50 states. They call them the 50 states, but they're charter states. Every last one of them now are governing over what? A non-self-governing territory. What does that mean? That means the Moors aren't governing their own territory.
Right.
It's non-self-governing. It's not governing itself. So the administrators, which is the colonists, have been governing over these Moors who are non-self-governing. Moors didn't have their 3 branches of government. We wasn't passing bills and enforcing said bills. This is the problem. Where's your government, Moors? If you don't have no government, that means it's non-existent. Which means you can't self-govern. Because you don't have no government. And the only way to have a government, first you have to have what? A state. And the state is recognized by what? Its constitution. But the constitution has to be what? Ratified, deposited, and promulgated in accordance to what? International law. So right here it's saying, you gotta listen to this. And this is very important for the Moors, especially the Moroccan nationals who are officers of their state. Because the competent authority of Moroccan states, from time to time, you're going to deal with what? Okay, let's go to the board. You're going to deal with what? You're going to deal with threats, breaches, and aggression. Right? So they're going to try to threaten your laws. They're going to try to breach your laws. They're going to try to be aggressive against your laws. See, this has already been manifested. Okay, well, how do you deal with this? Okay, well, now you need acts. What are acts? Legislation, laws, statutes. Where's your acts, Moors? That now sets up what? Prevention, to protect you, right? It's about prevention. These are preventive, this is preventive language. This is law. This is your legal argument. This is your legal defense in international law, but then you need to bring it back home to your Moroccan state and make it the language of Moroccan law, Moroccan statute, Moroccan legislation. Okay, let's read it again. Section 3. The states parties to the present covenant, including those having responsibility for the administration of non-self-governing, right? So the responsibility, who has responsibility? The United States, right? They're practicing what? As being administrators over the non-self-governing Moors who aren't governing themselves, right? And trust territories, right? And Moors look at the Treaty of Peace and Friendship. Article 22 talks about a trust, right? The trust. The trust is the land, right? That's what it is. It's a trust. Okay? It says, so the United States shall, see this word shall? The United States shall, let's do it like this. The United States shall, since they're the administrators, right? They shall promote the realization of the right of self-determination. They're supposed to promote it for Moors. Keep in mind now, the United States is a party to this. They signed these contracts. They have an obligation to help the Moors to get into a status of self-governance because the Moors now are getting back into the three branches of government. They're enforcing what's commonly known as the triple principle of the Act Out of Serres of 1906. Right? So what's the triple principle? Sovereignty and independence, that's number one. What's number two? Interior domains, right? What's number three? Economic liberty without any inequality. Those are the three steps of statehood. And guess who's supposed to help us with it? The United States and the several charter states. But instead, what are they doing? They're trying to do what? They're trying to prevent. They're trying to protect. They're trying to protect their own best interest. Why are they trying to protect their own best interest? It's because they have what? Legislation and statutes and laws. And they turn around and say, well, you Moors are breaking our laws by trying to decolonize. Oh, but that's your internal laws, United States. That's your internal laws, several Union states. Your internal laws do not supersede international law. And international law are what? Treaties. And you said through your own constitutions that the supreme law of the land is what? Treaties. So the United States and their several Union states have internal laws that contradict international laws, and guess what? Their internal laws automatically become null and void. But that don't mean they're not going to try to maintain threats, breaches, and aggression, but now we're setting forth what? Acts. And what are acts? Laws, legislation, right? Statutes. That's what Moors were in the absence of. Okay, so check this out. So the United States shall, let's take from the word shall. The United States shall promote the realization of the right of self-determination. They're supposed to promote it, mean assist. And shall respect that right. That right for Moors to get into statehood. In conformity, listen, in conformity, look what they say in the United States are bound to. Listen to what they say. In conformity with the provisions of the Charter of the United Nations. Let me ask you Moors a question. Why haven't your Moorish American teachers read the Charter of the United Nations out loud to you if, in fact, some of your protections as Moors can be found in the Charter of the United Nations? That's the question. Why don't they read it to you? All international law talks about the Charter. You know why they talk about the Charter? Because the Charter is the foundation of how these resolutions came to be in the first place. The Charter is recognized by states. And all those states came together and enacted international law. The charter is nothing but what you call a pass-through. The charter is nothing but a hub where all the states come together at one big, giant international table. It's a huge round table where 193 heads of states sit at this huge round table. And all these states put together international law, which is statutes. And that understanding is all states on planet Earth are going to adhere to said international law, which makes them international treaties. Most Americans don't know nothing about that. But the charter gives us rights under what? Article 73 of the charter. Moore's got to look at Article 1, Section 2, and go look at Article 55, and then go look at Article 73. Article 73 is a rights of indigenous people's article by itself. We're not going to read it, but go read it yourself. Be in scholarship. But this is where the Moors could have found some support for our protections. And guess where the United Nations headquarters is located? At least the primary one. And what's commonly known as Manhattan, New York. A stone's throw away. Yep. Keeping in mind that right now, just for the record, I want to say a shout out to the Moors that's in Ante, New York, because the Moors right now, they've invoked their constitution. They're working on getting into full statehood. So I want to say a quick shout out to the Moors in that territory who restoring it back into a Moroccan state. Shout out to y'all. Mm-hmm. So why did I go over that brief exercise? You see, the United Nations is trying to tell you Moors where to find your rights. Going back to this convention against the taking of hostages, this paragraph 2, Nova, can you read it again?
Recognizing in particular that everyone has the right to life, liberty, and security of person, as set out in the Universal Declaration of Human Rights and the International Covenant on Civil and Political Rights. Reaffirming the principle of equal rights and self-determination of peoples as enshrined in the Charter of the United Nations and the Declaration on Principles of International Law concerning friendly relations and cooperation among states in accordance with the Charter of the United Nations, as well as in other relevant resolutions of the General Assembly.
Pause. Keep in mind, what are we talking about right now? We're talking about what? How to counter terrorism. We're reading a treaty that deals with terrorism. All remember that. What is the scope of this particular treaty, right? What is its use? What is its function? What is it about? What's the main objective of it? It's about how to counter what? Terrorism. So these words about there shouldn't be no terrorist attacks. We got to stop it and prevent it. How do you stop it? Well, you need some laws to say, first of all, it's a what? It's against the law. It's breach of law. It's a threat of law. It's aggression against this said law. Let's continue.
Considering that the taking of hostages is an offense and grave concern to the international community, and that in accordance with the provisions of this convention, any person committing an act of hostage taking shall either be prosecuted or extradited. Being convinced that it is urgently necessary to develop international cooperation between states in devising and adopting effective measures for the prevention, prosecution, and punishment of all acts of taking of hostages as manifestations of international terrorism.
All right, so this is about terrorism, right? And Morris keeps saying they're hostages and they've been kidnapped, and that's a lie. Well, why do I say that's a lie? Because they're saying they don't want to recognize the United States civil and criminal jurisdiction. They say that anything that the police and the sheriffs, the prosecutors and the magistrates does against Moorish Americans, they're saying they're breaching the Moorish Americans' rights. The rights are founded in law, right? But before we keep reading this, and we'll probably end up reading this in the next class, but I need to show the Moors something as a recap. Because since we can already start talking about hostages, because Moors they love to talk about this word hostages, right? They saying they're hostages, they've been kidnapped, and they say the United States is performing terrorist acts. Because the Moors keep saying they're foreign nationals. They say these foreigners are doing something against them because they're foreign nationals. Moorish Americans are not foreign nationals. Moorish Americans are still naturalized citizens of the United States under the 14th Amendment. And that's true. Let me prove to you what international law says to the Moors. Listen, and I got to pause right there, because Moors keep saying they've been kidnapping hostages. No, you haven't. You come under the civil and criminal jurisdiction of the United States, and they're treating you like a naturalized Dred Scott. Let me prove it to you. They have rights to do what they're doing against Moorish Americans, because Moorish Americans are either stateless, and it means they come under the protection of the United States. Let me prove it to you. Okay. What's the name of this case?
Case concerning rights of nationals of the United States of America in Morocco.
Right. So at the top it says International Court of Justice, right? Reports of judgments, advisory opinions, and orders. Case concerning rights of nationals of the United States of America in Morocco, right? France versus United States of America, year 1952. Now, let me pause right here before I go a little deeper. Why does the United States promote this case? Why don't they teach their Americans about this case? Why didn't Fox News and CNN and all the other local news channels talk about this case in 1952 all the way to the year 2023? Nobody's talking about this case. Let me tell you something, Moors. White Americans don't know nothing about this case. If they did, they would understand why Moors are acting the way they're acting. Black people don't know nothing about this case. Evidently, Moorish Americans don't know nothing about this case either. Why aren't the Moorish American teachers reading this case out loud to the Moors? This is the blueprint. It points out all the problems of the Moors in this case. It also points out the solutions. It talks about problems and solutions. But this is what you call case law. This is the legal arguments. This was the legal defense. Based upon what? What was both sides? France and the United States of America were both standing on what? Well-settled principles of law. What laws were they using throughout this whole case? Treaties. Treaty, 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 treaty. That's all they were using. In addition to, they were invoking what? International law as well, because they were invoking the charter obligations. But nobody talks about this case. Why is that? It's only been out since 1952, and guess what? It's free. All you got to do is just download it. It's free. Nobody's selling it for $50 or $100. It's not a part of no package. It's free. United Nations makes it free. It's case law. Anybody that's an attorney, a judge, will tell you the first thing you do is look up what? Jurisdiction, right? You always challenge jurisdiction to see if the court can even listen to a case. But who's challenging jurisdiction? It was typically an attorney doing that, right? And what are they talking about? They're talking about what's the legal argument? What's the legal defense? When they say legal argument, legal defense, what are they really saying? They're saying, what statute are you using? What laws are you using? What legislative act are you using to say someone violated your right? And that's what they're talking about, the legal argument, the legal defense. It's based in laws. Guess what this is? Law. This is case law. You go back and look at case law, or you look at statutes. Most judges end up with case law because they're looking at what? The statute. They're looking at the statute, they're looking at the Constitution, and they're looking at the violation of what took place. So whatever so-called alleged crime it is, judges, attorneys are looking at what? Statutes to see what the law is, right? They're going to look at the Constitution, and they're going to look at previous case law. And this is previous case law. Moors ain't standing on this well-settled principle. They don't know nothing about it. This is shameful. It just baffles me. Let me prove something to the Moors as a recap. I'm not going to keep the Moors long today. I'm going to keep it short. Okay, if I put in Control F, okay, Control F, and I type in the word unavoidable. All right, Control F, type in the word unavoidable. U-N-A-V-O-I-D-A-B-L-E. O-I-D-A-B-L-E. Okay, it's going to take me straight to in the judgment. The word unavoidable is going to pop up. It's only mentioned one time in the judgment. Okay, it's on page what? 199. Here's what the Moors got to understand. I can't even read about hostages until you understand that you're not a hostage. You're just simply a naturalized Moor subject, i.e. a protege. What's a protege? Moors who are protected under the civil and criminal jurisdiction of the United States. Then they have a higher definition, say proteges are those Moors who are now working for the government of the United States or are more working for the charter states. So it's two different definitions when it comes to protege, but protege just means you're protected under the civil and criminal jurisdiction of the United States and the several Union states. Okay, all right, so let's take it from it is clear.
It is clear that in 1937, France, representing Morocco, and Great Britain were proceeding upon the assumption that certain of the provisions of the Act of Algeciras recognize a limited consular jurisdiction for the purposes of the judicial proceedings therein described.
Pause. Okay, let me read it again. Context. It is clear that in 1937, France, representing Morocco, so France under the Treaty of Fez of 1912, France was what? A de facto sultan overseeing the Empire of Morocco. That's what the case points out right there. So the Empire of Morocco is also who is located? The United States of America, because the United States of America is where? In Morocco. That's the name of the case. That's the title of the case. The case is cited. The case is cited as the United States of America in Morocco. It's about the rights of American nationals in Morocco. And France was overseeing the Empire of Morocco. Okay, so from the top, it is clear that in 1937, France, representing Morocco, the Empire of Morocco, and Great Britain were proceeding upon the assumption that certain of the provisions of the Act of Algeciras of 1906 recognized a limited consular jurisdiction for the purpose of the judicial proceedings there described. So under judicial proceedings, the Act of Algeciras of 1906 gave certain limited rights to the European powers who had naturalized Moors. So therefore, the United States of America, as an example, and their several charter states, they're using the Act of Algeciras, which is a Moroccan treaty, as their treaty right to have judicial proceedings, right? To have judicial proceedings over Moors. We're going to learn more about that. But so far, this is what the World Court is saying. Okay, let's continue.
The court is not called upon to examine the particular articles of the Act of Algeciras which are involved. It considers it sufficient to state as its opinion that the consular jurisdiction of the United States continues to exist to the extent that may be necessary to render effective those provisions of the Act of Algeciras which depend on the existence of consular jurisdiction.
Pause. Okay, this paragraph. Listen to what the court is saying. The court, right, the International Court of Justice, is not called upon to examine the particular articles of the Act of Algeciras which are involved. It considers it sufficient to state as its opinion that the consular jurisdiction of the United States continues to exist to the extent that they may be necessary to render effective those provisions of the Act of Algeciras which depend on the existence of consular jurisdiction. What is jurisdiction about? Judicial proceedings. It's about judicial proceedings. It's about judicial proceedings. Over who? Moors. This is what they're talking about. So why are they talking about the Act of Algeciras? Because the Act of Algeciras set forth consular jurisdiction in the Empire of Morocco. So whoever's enforcing the treaty gets to now enforce consular jurisdiction. The United States has consular jurisdiction, but it's limited. They say it's limited. They have limited jurisdiction over Moors. Why? Because the Moors were asleep. So the Moors have consented and acquiesced to the United States jurisdiction. This is why the court said they get to have limited. Why is it limited instead of full or absolute? It's because the United States is what? Foreigners in Morocco. Only indigenous inhabitants of the land, i.e. Moroccans, get to have full jurisdiction. We're going to learn about that. So in the meantime, while the Moors are sleeping under the protectorate status, the United States had a chance to hold on to jurisdiction over Moors, both civil and criminal, and to maintain what? Judicial proceedings.
This interpretation of the act in some instances leads to results which may not appear to be entirely satisfactory. But that is an unavoidable consequence of the manner in which the Algeciras Conference dealt with the question of consular jurisdiction. The court may not, by way of interpretation, derive from the act a general rule as to full consular jurisdiction which it does not contain. On the other hand, the court cannot disregard particular provisions involving a limited resort to consular jurisdiction, which are in fact contained in the act, and which are still in force as far as the relations between the United States and Morocco are concerned.
This is 1952. Listen to what the court is saying. They have some sympathy for the Moors. Listen. This interpretation of the act, right, the Act Algeciras, in some instances leads to results which may not appear to be entirely satisfactory. What's not entirely satisfactory? The fact that you got to let the United States hold on to colonialism over the empire of Morocco and the Moors. It's unsatisfactory to the ICJ. I'm going to explain why in just a moment, why they're saying this. It says but. See that word but? That's a powerful word, isn't it? Okay, let's take it from the top. The interpretation of the act in some instances leads to the results which may not appear to be entirely satisfactory. But, right, now the judge is saying that was their emotional comment. Now they're getting into what? The strict sense of the contract. Now they're reading the contract saying, but we're going to have to enforce this contract. That's why they're saying but. They're going to go right back to the contract now, right? They didn't tell you how they personally feel. Now they're going to get back to the law, the legal argument, the legal defense. Okay, it says but that is an unavoidable consequence on a matter in which the Algeciras Conference dealt with the question of consular jurisdiction. You see, the Act Algeciras said to wake up the Moors. It's about Moorish governments. And nobody woke up the Moors from 1906. And the ICJ is looking and saying, 12 signatory powers, the European powers, the Christian powers, right? They all have the obligation to wake up the Moors. And put the Moors back into a Moorish government, i.e. statehood. Nobody did it. And ICJ is looking at this saying, man, the treaty said to wake up the Moors. Why didn't y'all do it? And they said, oh, well, these Moors didn't wake up either on their own. Moors shared some responsibility for waking up. They didn't do it. It's 1952. Noble then came and gone. 1929, Noble's gone. Now we're in 1952, and the Moors ain't done nothing right to get their rights through statehood, to enforce the Act Algeciras. But wait a minute. How can Moors enforce the provisions of the Act Algeciras if they never knew it existed? Moorish American teachers didn't tell you about it, did they? Your grand sheiks didn't tell you about it, did they? So you got to understand what's happening here. We've been led astray as a people. We've been led away from the Act Algeciras. Let's say it again from the top. This interpretation of the act in some instances leads to results which may not appear to be entirely satisfactory, but that is an unavoidable consequence of the manner in which the Algeciras Conference dealt with the question of consular jurisdiction. Nobody woke up the Moors. The court cannot, by way of interpretation, derive from the act a general rule as to full consular jurisdiction, in which that's what the United States wanted, which it does not contain. On the other hand, the court cannot disregard particular provisions involving a limited resort to consular jurisdiction, which are in fact contained in the Act, and which are still in force as far as the relations between the United States of America, the Americans, and the Empire of Morocco for Moroccans are concerned. Two different parties. But wait a minute, what are they specifically talking about? Let's go to it real quick. What are they saying is unavoidable consequence? Okay, all right. First of all, in 1880, the right of protections in Morocco, Article 15, the Moors had an obligation to do what? First of all, the Moors were supposed to, on their own, they were supposed to follow the provisions of the treaty. This is 1880 versus the Act of Algeciras of 1906, right? So the Moors had 26 years from 1880 to 1906 to follow these provisions, then come back. Even to this very day of 2023, they didn't follow the provisions of the right of protections in Morocco, Article 15 of the Madrid Convention. They didn't follow it, paragraph 1, and return to Morocco. Right? Okay, what else? Why else is the court looking at this? Okay, let's go to the Act itself, the Act of Algeciras. Let's go to Article 102. Okay, Control F. Okay, 102. Okay, what does Article 102 say?
Article 102, every confiscation, fine, or penalty must be imposed on foreigners by consular jurisdiction and on Moorish subjects by Sharifian jurisdiction.
Okay, so Article 102 said that every confiscation, fine, or penalty must be imposed on foreigners by consular jurisdiction and on Moorish subjects. So the ICJ is looking and say, man, we got to enforce these treaty provisions. Article 102 says there must be a consular jurisdiction. It must be a consular court. It has to be a consular court because the treaty recognizes consular court. Okay, well, who are the consular court judges? Well, there wasn't any because France had so-called had consular court, but they had a bunch of Frenchmen sitting there acting like they were Moors. So the ICJ kicked that out and said, no, that's unacceptable. Where the heck are the Moors? Oh, there ain't no Moors? Okay, then guess what, France? You're not the competent authority. So now we're going to have to let the United States so-called oversee consular court. And instead, the United States said, man, get rid of that consular court. Let's just make sure we just keep using our inferior courts against these Moors, because these Moors keep running around saying that what? Americans. You don't need consular court if there ain't no dang on Moroccans. Moors run around saying they're Americans. Well, you don't need no consular court when it's American on American dispute. No. You only need consular court when it's Moroccan on American dispute. And the Moors run around saying, I'm American. So therefore, these Moors are actually what? Moorish subjects. Isn't that what your Moorish American so-called master teacher told you? That you're a Moorish subject? It's sojourner Moorish subject. That's what you are. And since the Moors aren't sitting in the competent authority of the consular jurisdiction, the United States had a chance to invoke Article 102 over who? Moorish subjects. This is what the treaty says. This is the ICJ is pointing out. They're standing on the provisions of what? A treaty. Because treaty is supreme law of the land. The ICJ saying, you Moors are messing up. You've had since 1880 to fix this. They standing there in 1952 saying these Moors still ain't woke up. Well, why couldn't the Moors wake up? It's because our overseers had us on the wrong path. Who are the overseers? Well, they look just like you and I in the mirror. They told us we were Negroes, blacks, coloreds, African Americans, and Moorish Americans. They told us we was Indians. They told us we was Hebrew Israelites. They told us we was Baptists. Everything but Moroccan. And that's the truth. But we're all what? Moorish subjects until you do what? You return back to Morocco. Let's prove it. What did 1880 say? No, 1880, Article 15, Treaty Madrid.
Any subject of Morocco who has been naturalized in a foreign country and who shall return to Morocco shall, after having remained for a length of time equal to that which shall have been regularly necessary for him to obtain such naturalization. Choose between entire submission to the laws of the empire and the obligation to quit Morocco, unless it shall be proved that his naturalization in a foreign country was obtained with the consent of the government of Morocco.
All right, so these subjects of Morocco, these Moroccan subjects, these Moorish subjects, right, have been naturalized by the United States of America. But these Moorish subjects had a treaty right and obligation to return to Morocco, and after that, they had to do what? Choose between entire submission to the laws of the empire, right? And the laws of the empire can only be derived through what? A government of Morocco. But there's no government without it being a state first, that then creates the government of Morocco. There is no government without state. So we have to return to what? State government of Morocco. Provincial state government in each of the territories. That was the obligation. If not, paragraph 2.
Foreign naturalization heretofore acquired by subjects of Morocco according to the rules established by the laws of each country shall be continued to them as regards all its effects without any restriction.
So this was the ICJ is reading. They're reading paragraph 2. They got to let the United States hold on to the Moors without any restrictions. Because the United States has what? Laws. The United States has what? Laws. Moorish Americans don't have no laws. The United States got laws. There's several chartered union states have laws. Which means the Moors came under civil and criminal jurisdiction of the United States, and there's several union states. And the ICJ backed that up. Right? The ICJ backed that up in 1952. And they say, you know what? This interpretation of the act in some instances leads to results which may not appear to be entirely satisfactory. You're reading the judgment, page 199. But that is an unavoidable consequence on the manner in which the Algeciras Conference dealt with the questions of consular jurisdiction. So the Act of Algeciras and the Treaty of Madrid recognized the United States as having jurisdiction over Moors because the Moors were not invoking their own rights through statehood. Why else were they upset with? Didn't they say that France was overseeing the empire? Why did they mention France? They said France was representing Morocco. So why did they point that out? Because they knew France had obligations to the Moors. Mm-hmm. Okay. Now you go to the Treaty of Fez of 1912. Okay, let's go ahead and read.
Protectorate Treaty between France and Morocco, signed at Fez on March 30th of 1912. The government of the French Republic and the government of His Sharifian Majesty, desirous of inaugurating a regular regime in Morocco based upon internal order and general security, which will make it possible to introduce reforms and to ensure the economic development of the country, have agreed upon the following.
Okay.
Article 1. The government of the French Republic and His Majesty and the Sultan have agreed to establish in Morocco a new regime comprising the administrative, judicial, educational, economic, financial, and military reforms which the French government may seem fit to introduce within the Moroccan territory. This regime shall safeguard the religious status, the respect and traditional prestige of the Sultan, the exercise of the Mohammedan religion, and of all religious institutions, in particular those of the Habus. It shall include the organization of a reformed Sharifian Maghzen.
Okay, so France, this sentence right here, it says, the Sultan told France through this treaty supreme law of the land, it's an obligation, responsibility, right? You must observe the application of the text. But what's this sentence say right here? It shall include the organization of a reformed Sharifian Maghzen. So France was supposed to reform the Sharifian Maghzen. Okay, well, what's a Maghzen? Okay, this is Wikipedia, a basic definition.
Moghzin, Arabic, Moroccan Arabic, Berber languages. It is the governing institution in Morocco and in pre-1957 Tunisia, centered on the monarch and consisting of royal notables, top-ranking military personnel, landowners, security service bosses, civil servants, and other well-connected members of the establishment. The term Moghzin is also popularly used in Morocco as a word meaning state or government.
Okay. So Moghzin means the term. Moghzin is also popularly used in Morocco as a word meaning state or government. So the Moghzin is what? The state or government. But you can only have a government of a state. Right? So wait a minute. So the Moghzin is a state or government. So now you go back to the Treaty of Fez of 1912, and it says right here, France was supposed to do what? It shall include the organization of a reformed Sharifian Moghzin, which means France was supposed to put together what? The Moroccan state, Moroccan government again. For who? Moors. Because Moors are the ones supposed to be running the Moorish government. France failed to establish and wake up the Moors. The ICJ knew this. Because the ICJ kept talking about this Act Algeciras of 1906. Keep in mind, this is 1912 right here with this treaty. 6 years later, they enacted this. France like, okay, we'll wake up the Moors. And they never did it, did they? Right? So, okay, now we go to the Act Algeciras, 1906. Right? So now we go to Article, let's say Article 2. Okay? Go to Article 2. Okay, Morris, you go to Article 2 of the Act Algeciras. Okay? Matter of fact, let's read Article 1 first.
Article 1. The conference summoned by His Majesty the Sultan to pronounce on the measures necessary to organize the police declares that the following provisions should be made.
Okay, so he's putting together the police. The police are who? Moors. Listen, Article 2.
Article 2. The police shall be under the sovereign authority of His Majesty the Sultan. It shall be recruited by the Moghzin from Moorish Mohammedans, commanded by Moorish Caids, and distributed in the 8 ports open to commerce. Okay, so the Moghzin, which is the state, the government, right, from the Moorish Mohammedans, right, from the Moorish Caids. So it's all about going to establish this government from the Moors. Okay, let me type in the word Moor. How many times the word Moor mentioned in here? Okay, just a moment. Watch this. Moor. M-O-O-R. Okay? Watch this. I'm going to click down. It's Article 2. Where's the next place that says Moor? Okay, Moor. Right there. Okay, well, which article we in now? All right, that's Article 4. Okay. Article 4. These officers and non-commissioned officers for a period of 5 years, to date from the ratification of the Act of the Conference, shall give their service to the organization of a body of Sharifian police. They shall assure instruction and discipline in conformity with the regulations to be drawn up in respect thereto. They shall also see that the men enlisted are fit for military service. In a general way, they shall supervise the administration of the soldiers and superintend the payment of their salary, which shall be effected by the admin, assisted by the accounting officer instructor. They shall extend to the Moorish authorities invested with the command of these bodies their technical aid and the exercise of the said command. Okay, just a moment. Where else does it say more? Okay, let's click on down. Okay, just a moment. What article is this? Article 15. All right, let's take it from the top. Article 15, the arms, parts of guns, and ammunition intended for the troops of His Sharifian Majesty will be admitted after the fulfillment of the following formalities. A declaration signed by the Moorish Minister of War describing the number and nature of such articles ordered abroad must be presented to the legation of the country of their origin, whose visa shall be affixed thereto. So it's about the Moorish Minister of War. We're talking about Moorish government here. There's no Moorish Minister of War
unless there's a state government recognizing Moors as being the competent authority of said state, and the state government was called what? The Mosin. The Mosin is not an office. The Mosin is what? The state and the government that represents said state. The Mosin, right? The term Mosin means what? Meaning state or government. Going back to the Act of Service. So the Moorish minister of war, evidently he was a Moor sitting in a position in the office of a government of what? A state. Mm-hmm. And it was France's obligation to help the Moors reestablish the state. This is what you got to understand, okay? Listen. Where's the next time it says Moor? Okay. Now we're in what? We're still in Article 15. It jumps down, and it's talking about these Moors again.
The passage through the customs of the cases and packages containing the arms and munitions delivered at the order of the Moorish government shall be effected upon the presentation.
Pause. Who's giving orders? Okay, let me read it. The passage through the customs of the cases and packages containing the arms and munitions delivered at the order of the Moorish government. Who's supposed to be giving orders? Moors. Okay, let's go back to the case. Moors will go back and read this. The word Moor is mentioned 42 times. 42 times in the Act Adversaries. This is why the ICJ is flipping out. ICJ is looking at the Act Adversaries and said, do you know how many times it says Moor in here? Mm-hmm. And the ICJ is looking in the courtroom, said, I don't see no fezzes. I don't see no Moorish faces. I don't see the Moorish government. France. You overseeing the empire, you're supposed to do what? Going back to the Treaty of Fez. You're supposed to do what? You shall include the organization of a reformed Sharifiya Mosin. Where was it reformed? In 1952. France hadn't done it. France didn't want to wake up the Moors. The United States of America didn't want to wake up the Moors. And the other 10 European states didn't want to wake up the Moors. But it was an obligation, and the ICJ is upset about it. Listen, they're upset about it. Say, France, you're supposed to be representing Morocco. France supposed to be representing Morocco and supposed to wake up the Moors. That way the Moors could deal with what? Judicial proceedings. Mm-hmm. Over who? Foreigners, i.e. American citizens. Mm-hmm. But they didn't do it. Moors didn't wake up. And the colonists didn't wake us up. So the ICJ is upset about it. So the ICJ turns around and says, you know what? This is terrible. Look at this. Ain't no Moors in the courtroom. The Sultan's not here. The Moors aren't here. Because they in the United States call themselves the black man. The Moors in the United States call themselves Negro and colored. The Moors in the United States talking about their African Americans. The Moors in the United States talking about their Indians. The Moors in the United States talking about their Hebrew Israelites. The Moors in the United States talking about their Baptists. The Moors in the United States talking about their Moorish Americans. Everything but what? Moroccans. And the court's upset about it. No, from the top.
This interpretation of the Act, in some instances, leads to results which may not appear to be entirely satisfactory, but that is an unavoidable consequence of the manner in which the Algeciras Conference dealt with the question of consular jurisdiction. The court cannot, by way of interpretation, derive from the Act a general rule as to full consular jurisdiction, which it does not contain. On the other hand, the court cannot disregard particular provisions involving a limited resort to consular jurisdiction, which are, in fact, contained in the Act, and which are still in force as far as the relations between the United States and Morocco are concerned.
So therefore, the ICJ was upset because they did not see Moorish fezzes sitting in the courtroom. They did not see the Sultan. There was no Moxin. What's the Moxin? Moorish government. France supposed to be the de facto sultan standing next to the Moors. The ICJ got upset because they knew France was not adhering to the provisions of the Act d'Albufex of 1906, and nor was France adhering to the provisions of the Treaty of Fez of 1912. The ICJ knew it. So they was blaming France, and they was also blaming the Moors. Because the Moors had did what? They consented and acquiesced to the jurisdiction of the United States. The United States ended up with a limited jurisdiction. Limited resort to coastal jurisdiction. They gave them a limited jurisdiction over Moors. Not full, but limited. Okay, then how do Moors get rid of the limited jurisdiction? You know how we do it? We enact laws that now says we no longer need what? Their protections. But that can't be your verbal decree. You got to enact laws, but the only way to enact laws has got to be through what? A state. It's got to be through what? It's got to be through a mountain. It's got to be through a mountain, which is what? A state or government, and there can be no government without the state. They're giving you the answer to the test, Moors. Well, why did I go through that exercise again? Because as we start to get ready to read about the taking of hostages, Moors keep thinking that, yeah, man, let me read this because I've been kidnapped. Let me read this because I'm a hostage. No, you're not. The International Court of Justice gave the United States a limited judicial right over you through your own treaties because you're still a what? Moor subject. Moors are still Moor subjects. And on Article 102 of the Act d'Albufex, the United States has jurisdiction over you until you come back home, and now you have jurisdiction over them. And until then, they get to maintain the protectorate status over us. So therefore, what needs to happen? Moors got to enact laws, statutes, legislation. But what type of laws, statutes, and legislation? Moroccan laws. There's no such thing as Moorish American laws. It don't exist. So therefore, the United States is not breaching the laws of Moorish Americans because there ain't no such thing as Moorish Americans. There ain't no such thing as Moorish American laws. So in class 114, we'll keep reading over this particular legislative act, commonly known as the International Convention against the Taking of Hostages. Because now, when the Moors return to Morocco and follow the treaty provisions, the instructions of the Madrid Convention of 1880, Article 15, paragraph 1, now we can say, when they detain one of us, especially if we're a diplomat, protected person of our state, now we can say officially that we're hostages because our laws, our statutes say that we are hostages. I end with that. Islam.
Islam.